Hello, my name is Dave Zapponi, and I'm the CEO of ECHO, otherwise known as the Educational Council of Homeowners. Thank you all for participating in this community conversation today. Case law update. ECHO is a 51-year-old statewide nonprofit association established to support HOA board members and engaged homeowners. Our mission is to foster a better quality of life in community associations through education, advocacy, and connections. For today's event, we have a few housekeeping items. These are now presented on the screen. This slide deck, the slide deck was sent to you all registered attendees prior to today's webinar. Please take a moment to review all our housekeeping items. Today, we have a large audience of HOA board members. We will do our best to answer your questions, but may run out of time. At the prerogative of the presenter, they may answer questions during the presentation or only during the Q&A session at the end of the webinar. We will answer as many questions as possible and throughout the day. In addition to the live Q&A session, I will answer some questions via text in the Q&A feature during the presentation. To prioritize your questions, please use the upvote button in the Q&A feature. Those questions with the most upvotes will be answered first. It's easy, simple, and simple to use. The thumbs up button in the bottom left corner of your screen. Please use that to prioritize the questions. Those questions with the most thumbs up will likely be chosen first. Also, please keep your questions general in nature and short. We may pass over those questions that are too complex or too long, so please keep them short. Specific questions about your community are best asked of your attorney or another qualified expert familiar with your particular situation. Please use the chat feature to report any technical issues and to communicate directly with other participants in the webinar. We do not monitor the chat room for questions. Now let me direct your attention to your monitor where you'll find our disclaimer. None of what is said during the seminar shall be construed as specific legal or expert advice from the speakers, sponsors, or ECHO. If you wish specific advice, we encourage you to contact your attorney or another suitable expert. The information we provide during this webinar is educational in nature and should not be relied upon for specific decision-making purposes. Thank you. This webinar and all of our events are made possible by the generous support of ECHO HOA professional service providers. Join me today in thanking them. Our registration sponsor is Levy Erlinger and Company LLP CPAs, MindMe Technologies, Silver Creek Association Management. And today's gift card sponsor is CM Squared. Please stick around till the end of the webinar for a chance to win this $50 Amazon gift card, and you must be present to win. Please support all ECHO professional members and especially our sponsors. They make our educational programming possible at little or no cost to you. And now, Luis Sarmiento, our speaker, is an associate attorney at Shear Smith & Kenny LLP, where he advises homeowner associations and other mutual benefit corporations, businesses, and individuals on common interest development, real estate, corporate, and general business matters. Luis advises homeowner association boards and officers on matters including governance, development, and enforcement. Luis is also the general counsel for ECHO, or Shear Smith & Kenny. So thank you so much for joining us today, Luis. We look forward to your presentation. Take it away.
Thank you very much, Dave. So if we could start off with a roadmap for today. Cases I will be discussing have been issued or will become effective or have the impacts since our last ECHO case law update in the spring of this year. You'll see there's Morris, there's Dubak dealing with anti-SLAPP. Next, DOSIC v. ALS lien services, as well as us getting into select changes in statutes affecting common interest development. So total 3 cases, 4 bills enacted into law. And then at the very end, we'll also get into the Corporate Transparency Act. We covered this previously, and I understand that there are other webinars that got into detail, but since the effects would be felt and that all registration needs to be done by January 1st, 2025, figured it'd be important to cover it here. So our first case, Morris v. West Hayden Estates First Edition Homeowners Association. Question here digs into what rights a person has in the exercise and the enjoyment of their protections under the Fair Housing Act. Or I have it, how much is too much Christmas spirit? Jeremy and Christy Morris are homeowners in and members of the West Hayden Estates First Edition Homeowners Association. They sued their HOA in federal court, alleging essentially that the HOA discriminated against them on the basis of religion in violation of the Federal Fair Housing Act. So here we'll see that the parties are Jeremy and Christy Morris, and the defendants here are going to be the HOA. This is an Idaho corporation, and we are talking about this because this is in the U.S. Court of Appeals in Ninth Circuit, which covers California. It's Idaho, California, Hawaii, a few other states. So sticking here for some context, in December 2014, prior to moving into their HOA, the Morrises posted on Facebook that they would be offering free hot chocolate to anyone passing through their neighborhood. At the time, it was Grouse Meadows, to look at their Christmas lights. Within a day, an estimated 200 families had taken them up on their offer. And over the following 8 nights, between 200 and 100 families stopped by each night to see the Morrises' Christmas decorations. On 1 or 2 of those nights, a bus brought by residents from a retirement home to see the lights and to enjoy caroling. Visitors to this display enjoyed thousands of lights on the Morrises' home, free hot chocolate, Christmas-themed characters in costume, caroling, and even a live camel named Dolly. So you'll see on this next scene, on this next slide, there is actually a 91-minute documentary on Apple Plus. And oddly enough, it has a 100% critic rating on RottenTomatoes.com. So in December 2014, prior to moving into West Hayden, Jeremy reached out and everything, all the issues came up. So with the issues in 2014, in preparation for next Christmas and in 2015, the Morrises made an offer on a new home in West Hayden Estates with the Christmas program in mind. And before closing, the Morrises requested reviewing the CC&Rs. They contacted the HOA president to discuss the Christmas program, and they asked the president to call a meeting to address how the CC&Rs would impact the program. The president immediately scheduled an emergency meeting of the HOA board, which the Morrises did not attend. During that meeting, the members of the board looked up information about and watched YouTube videos depicting the Morrises' 2014 program on Facebook. And after doing so, the board was concerned that an event of that scale would not be consistent with the HOA rules and covenants. And at the end of the meeting, the board agreed to send the Morrises a letter advising them that hosting the proposed Christmas program would likely violate the CC&Rs. So on this screen, you'll see some sections that they highlighted. The letter stated that the program, like the one planned by the Morrises, would violate 3 sections of the CC&Rs. Section 5.4.1, which provides that properties in West Hayden Estates are not to be used for any purposes other than for single-family residential purposes. 5.4.2, which prohibits nuisances, including any noise which would interfere with the quiet enjoyment of any neighbor. And section 5.4.15, which instructs that any exterior lighting on an HOA home shall be restrained in design and that excessive brightness should be avoided. The letter also expressed concern about the Morris's increase in traffic that would likely accompany the Morris's Christmas program. Sounds so good, so far so good. But in the closing paragraphs, the letter writer wrote that they were somewhat hesitant of bringing up the fact that some of the residents are non-Christians or of another faith, and that they don't even want to think of the problems that it could bring up. They stated that it was not the intention of the board to discourage the Morrises from being part of the neighborhood, and they certainly don't wish to be entwined in any expensive litigation to enforce the long-standing rules or to fill up the neighborhood with hundreds of people and their language possible undesirables. The language said that neighbors respect the CC&Rs and show common courtesy to those around them, and that's the reason why people want to live there. Next. They all seem to live in apparent harmony until fall of 2015, when Jeremy and Christy began setting up the Christmas lights in preparation for their second annual Hayden Christmas Light Show. In October, the HOA board, via their attorney, sent the Morrises a letter expressing concern that the planned event would not comply with local zoning ordinances and would violate the HOA rules prohibiting nuisances, excessive lighting, and the keeping of animals other than ordinary household pets. The letter further stated, unless you request and receive written approval from the HOA board to conduct your planned event, the board has authorized this office to file an action seeking an injunction to prevent your event from occurring. The Morrises did not receive written approval, but went ahead with the program as planned. So for 5 nights leading up to Christmas, the Morrises surrounded their home with an estimated 200,000 lights, 30 volunteers, costume characters, several musical guests, children's choir, an antique cotton candy machine, and once again, Dolly the Camel. 4 commercial buses arrived carrying visitors to the event, and traffic supervisors were present to direct visitors' cars through the streets around the house. Again, the board took no legal action. So in 2016, the Morrises held a larger program, which had 5 buses and 48 volunteers, and added 4 hot chocolate elves to the attractions. 2017, the federal lawsuit was filed. So next, we'll get a little bit about the background as to the federal trial. So, well, actually, at the district level, the jury found in favor of the Morrises for each of their separate claims. But after trial, the district court granted the HOA's motion for JMOL, which is a judgment as a matter of law. And under the federal rules of civil procedure, a party can file a motion for a judgment as a matter of law during a few times in the process, in which they ask the court to find that a reasonable jury would not have legally sufficient evidentiary basis to find for a party on an issue under the controlling law. So since the district court found in favor of the HOA, the Morrises appealed here. So at the Court of Appeals, this next slide will cover what their review was. The Morrises contend that the HOA violated 3 provisions of the Fair Housing Act. Section 3604B, which makes it unlawful to discriminate against any person in the terms, conditions, or privileges of sale or rental in a dwelling or in the provision of services or facilities in common therewith because of race, color, religion, sex, familial status, or national origin. Section 3617 makes it unlawful to coerce, intimidate, threaten, or interfere any person in the exercise or enjoyment on the account of having its exercise or enjoyment being protected and granted. And section 3604C, which makes it unlawful to make, print, publish any notice, statement, or advertisement with respect to the sale or rental of a dwelling that indicates any preference, limitation, or discrimination based on, among other things, religion. So as to treatment and interference, here are the three, again, those three sections. So as to 3604, Morris has failed to point to any concrete adverse impacts suffered as a result of the behavior. But as to 3617, the court found that the Morrises did provide adequate evidence. As to 3604, dealing with making, publishing, printing any notice or statement with regard to any preference, the court found no legal sufficient evidentiary basis for a reasonable jury to find that the 2015 letter indicated a preference for a religious person purchasing them or the Morris's home. Now, again, the letter did say, please keep in mind there may be non-Christians, but it did not say we want non-Christians to be living in the home. So on the next slide, we'll talk about the harassment element of the West Hayden Estates residents. The Morrises contended that in addition to those three claims, that the HOA's toleration of threats and harassment targeted the Morrises by other residents of the HOA, and that violated 3604B of the Fair Housing Act. And the power to address discriminatory conduct against the resident by a third party depends upon the extent of the defendant's control or other legal responsibility that the defendant may have with respect to the conduct of that third party. So to say liability for third party conduct under the Fair Housing Act is fact dependent. And on the facts in this case, the HOA was not liable for the allegedly harassing conduct of other residents. So implications for common interest developments. Please keep in mind that discrimination based on race, religion, color, sex, familial status, or national origin can take many forms, including indirect ones, such as disparate impact. And just please be mindful that of that fact when enforcing facially neutral restrictions and regulations. Next, this is a case in California Court of Appeal. This concerns a neighbor-to-neighbor dispute, but the defendants were on the board. So here the question is whether or not the neighbor's statements and emails, whether or not it contributed to the public discussion of public issues such that they were protected under the anti-SLAPP statute, which we'll get to. But generally, the anti-SLAPP statute aims at encouraging participation in matters of public significance. Here, the ultimate question is determining whether that implicates, or the statements here implicated public interest as is required to be protected under the statute, and is whether the statement furthered the public discussion of the public issues that it implicated. So the parties here, Robert Duback is a condominium owner in a 6-unit HOA. And it's same as is the defendants, Sandra Idkoff and Jonathan Diamond, who appear to be husband and wife. And now to set the table, obviously this is a dispute among neighbors in which there were statements called by Idkoff and Diamond calling Duback a pathological liar, a racist, and a misogynist. So at trial court, in this next slide, we'll see the allegations by Duback. Duback sued Idkoff and Diamond for defamation, infliction of emotional distress, interference with economic advantage, and civil harassment. Idkoff and Diamond filed a special motion to strike, and the trial court rendered a 30-page statement on its decision. And it ruled that certain statements failed anti-SLAPP analysis, in which we'll get to and discuss the connection with the public issue and whether or not it affected the public interest. So next, just for context, anti-SLAPP is a two-pronged analysis. Again, the statute aims at encouraging participation in matters of public significance. So in case law, the court established a two-pronged analysis, and here, well, actually, I should get to the two prongs. The case here turned on the first prong of the anti-SLAPP analysis, which requires independent review of whether the statements counted as speech in connection with public issue of a public interest. Now, the phrases public issue of a issue of public interest seem to refer to the same thing, but it's difficult to imagine a public issue that is not an issue of public interest or vice versa. So the parties here weren't necessarily aimed at distinguishing. Rather, they wanted to have it simplified by referring interchangeably with public issues, and the court interchangeably used public issues and issues of public interest. So next, what is a public issue, or what's an issue of public interest? The case law has struggled to determine what makes something an issue of public rather than a private interest. It's been a struggle because the distinction between public and private is notoriously difficult to state in clear and simple terms. And the ambiguity between public interest is almost beyond the law. On some points, judges have been able to indicate what are characteristics of public issues. So the courts have used a 5-factor test to determine whether a statement implicates the public interest. One is that the statement concerns a person or entity in the public eye. Think of politicians. 2, the statement concerns conduct that could directly affect a large number of people beyond the direct participants. 3, the statements concern a topic of widespread public interest. 4, the issue is of concern to substantial number of people. And 5, the issue has been the subject of extensive media coverage. But the ultimate question is whether the statement furthered the public discussion of a public interest that the public issue that it implicated. So the Court of Appeal, you'll see on the next slide, content and context show that the emails from Itkoff and Diamond did not contribute to the discussion of public issues. Again, those important contextual factors, in addition to those five factors we discussed, the contextual factors include the identity and numbers of speakers, the audience, the location of the communication, and the purpose and timing of the communication. So here, the number of people affected by or involved in or who care about this intra-building issue is rather minute. The record offered no objective basis for saying anyone outside of the 6-unit building had any public interest that is poisoned in this relationship that's poisoned among the neighbors. And the matter of concern to the speaker and a relatively small specific audience is not a matter of public interest, this court found. So ultimately, the court indicated that the lawsuit did not concern a speech in connection with public issue or an issue of public interest. So this item alone doomed the special motion to strike, and the court threw out the anti-SLAPP motion. So, I mean, that's all to say that the DUBAC claims were able to move forward. To context, an anti-SLAPP claim is brought and essentially brings the matter of the anti-SLAPP motion to the priority, and that gets issued. And if a court finds that anti-SLAPP is involved, then the court would ultimately throw out the underlying claims. But that was not the case here. The claims were able to proceed. So on this next slide, we've got the implications for common interest development. So please remember that the right of the right to free speech does not protect one from the consequences of one's free speech. The primary purpose of anti-SLAPP laws is to protect individuals and organizations from frivolous lawsuits aimed at silencing criticism or public participation. These laws are designed to safeguard the freedom of speech and the right to petition the government, which are fundamental rights under the First Amendment of the US Constitution. But here, Itkoff and Diamond would need to defend the allegations, the underlying allegations of defamation, intentional infliction of emotional distress, interference with economic advantage, and civil harassment. So the next case, Dos Cox v. ALS Lien Services. There were 6 issues raised on appeal here. 3 issues were raised by ALS, and 3 issues were raised by the law firm defendants. Only 2 of those issues were approved for publication, but as far as our purposes here, the question is whether assessment collection companies are required to apply homeowners' payments to unpaid assessments before collection fees and costs. So the parties here. Teresa Dos Cox is the plaintiff and a homeowner member of the Danville Green Homeowners Association Incorporated, which is a mouthful, so I'll just say that either HOA or Danville Green. ALS Lien Services as the defendant and is an association assessment collection company. I imagine a fair amount of the attendees here might be familiar with. But notably, in addition to ALS, the law firm that provides legal counsel to ALS and 2 founding attorneys of that firm were named as additional defendants in the underlying action as alter egos of ALS. The issue involving the law firm defendants does not impact CID law in general, and actually those issues were not published, so we won't be covering that issue or the procedural issues raised in those unpublished portions of the opinion. So next, for background, homeowner Dos Cox was delinquent in the payment of assessment and owed Danville Green $1,239.18. Yes, this is a class action lawsuit and a state court of appeals case that we will be talking about that ultimately resulted in an attorney's fee award of over $1 million. This is all a result of a $1,239.08 delinquent assessment. So here, as a result of the $1,200, the HOA hired ALS to collect the unpaid assessment from Dos Cox. Next, as to that smaller amount, the facts leading this case can show why there can be a level of distrust between members and their association. So some quick math. Dos Cox initially owed $1,239.08. She entered into a 6 installment payment plan. She paid 5 of the 6 installments and asked for a second payment plan to cover that amount for that that 6th installment. ALS responded that after paying 5 of 6 installments, her balance was $1,074.90. But they proposed a plan to pay for the $1,074.90 balance with a payment plan that totaled $2,000, $2,033.19 to be exact. So quick math, she owed $1,239. The estimated payments were over $5,000, and she still had a balance of $1,074.90. So she said, hey, I owe $1,074.90. I'm going to send you $1,074.90. She should have a $0 balance. But ALS sent Dos Cox a pre-notice of default letter stating that Dos Cox still owed $830.73. ALS eventually closed the collection account and billed Danville Green for $425 in collection fees, which Danville Green paid. Next, The plaintiff originally filed a class action in federal court against ALS, alleging violations of the Fair Debt Collection Practices Act and California's unfair competition law, related to ALS's collection of unpaid assessments on behalf of homeowners associations. After the parties stipulated that the federal case would be dismissed and refiled in state court, the plaintiff was granted the opportunity to amend her complaint to add allegations that added the law firm defendant and the named partners of that law firm as alter egos of ALS. The state court also granted the plaintiff motion to bifurcate so that she'd be able to proceed first on her unfair competitions law action. And at the conclusion of the bench trial, the court found that ALS had violated the Fair Debt Collection Practices Act and entered judgment in favor of the plaintiff on her unfair competitions law cause of action. And it also found the law firm defendants jointly and severally liable for restitution and the class counsel fees as alter egos of ALS. So ALS and the law firm defendants appealed. Next, we'll see at the Court of Appeal, there were two issues under review in the published portion of this case. First, ALS appealed the lower court's rulings that the waiver of Civil Code Section 5655A in ALS's standard forms was invalid. Second, ALS appealed the trial court's determination that ALS's pre-notice of default letter violated the Fair Debt Collection Practices Act. Next, in more detail, as to the 5655 waiver, the payment plan that Doscox agreed to included a waiver of Civil Code Section 5655A, which requires payments first to be applied to assessments owed, and only after the assessments owed are paid in full shall payments be applied to fees and cost of collection, attorney's fees, late charges, or interests. ALS's standard payment plan included this waiver, and its standard collection terms require HOAs to agree to payment plans with this waiver. The Court of Appeals upheld the federal court's ruling that the waiver was void as a matter of public policy. And in coming to its decision, the court cited code section that bars the waiver of a statutory right when the public benefit of the statute is one of its primary purposes. To determine the primary purposes, the court looked to the language of the statute itself as well as the legislative history. Next, that's on the second claim. The Fair Debt Collections Practices Act prohibits a debt collector from engaging in certain practices to collect or attempt to collect a debt, including threatening to take an action that cannot legally be taken and threatening to effect dispossession of property where there is no present right to possession of that property. Now, case law has indicated that the threat need not be expressed, it can be an implied threat. And to determine whether the conduct violates the Fair Debt Collections Practices Act, courts have employed the least sophisticated debtor standard. That this standard provides a quotient of reasonableness and presumes the basic level of understanding and willingness to read with care. But it is designed to protect consumers of a below average sophistication or intelligence, or those who are uninformed or naive, particularly when those individuals are targeted by debt collectors. Next, looking at the language in the pre-notice of default letter, one of the key phrases was the sentence, if a payment is not received within 10 days, then Association Lien Services will record a notice of default. So notably, the Civil Code section prohibits, section 5720 prohibits the collection through foreclosure or delinquent assessments that are less than $1,800 or that are no more than 12 months old. So again, this is less than that $1,800 threshold, and it was less than 12 months mature. So Subsection B of that section imposes constraints on an HOA that seeks to collect or attempts to collect or secure a debt that is below $1,800 or 12-month threshold. Recording a notice on default starts the foreclosure process. It is the initial step following the notice of sale. The phrasing seeks to collect or attempts to collect suggests, the court found, or the court thought that it suggests an intention to cover these steps to commence and perfect the foreclosure process, not just the foreclosure sale itself. The court, in reviewing the pre-NOD language and using the least sophisticated debtor standard, they concluded that the trial court did not err in determining that ALS's pre-NOD letter violated the Fair Debt Collection Practices Act. So next is to the implications for CIDs. Associations, managers, collection companies must follow the highly technical assessment collection process. For any board members here today, this applies to you too. Please seek and heed the advice of counsel representing your association. Don't rely solely on the advice of counsel for your vendors. Again, they're counsel for your vendors, not counsel for the association. And please don't take the assessment collection process lightly. Board members, please remember that your association's vendors likely required that your association defend, indemnify, and hold them harmless if a claim arises out of or in connection with the services that the vendor supplies on behalf of your association. This all means that the association and your association's insurance company could be partly responsible for any of your association's vendors' corner cutting or unlawful actions. Next, we'll look at changes in statute. Issues cover balcony inspections, electronic secret ballot voting, reduced quorum for director elections, and association's responsibility for utility systems. First is AB 2114. You may recall that in 2020, a new civil code section took effect. This was section 5554. Under this section, the board of the association of a condominium project is required to cause a visual inspection to be conducted at least every 9 years of the exterior elevated elements for which the association has maintenance or repair responsibility. While the section is generally considered as being the balcony inspection requirement, please note that the exterior elevated elements is the operative term. The requirement applies to components that extend beyond exterior walls of a building to deliver structural loads to the building from decks, balconies, stairways, walkways, and their railings that have a walking surface elevated more than 6 feet above ground level, and that are designed for human occupancy or use, and that are supported in whole or in substantial part by wood or wood-based products. Also, this requirement concerns a waterproofing system associated with those components. So remember that CIDs are required to have their first inspection by January 1st, 2025, which is coming up. And then every 9 years thereafter, in coordination with the reserve study inspection process pursuant to section 5550. And all written reports shall be maintained for at least 2 inspection cycles for the association. Next is section 5129. This bill would authorize the association to adopt, I should say, going back to 2124, what the change was in this particular bill was that civil engineers, in addition to structural engineers and architects, are authorized to conduct the inspections for the exterior elevated elements. Sorry, going back to 5129, this bill would authorize an association to adopt an election operating rule that allows the association to utilize an inspector of elections to conduct an election by an electronic secret ballot, except as specified in the text, and notwithstanding the association's governing documents. This bill would require the rule to permit a member to change their preferred method of voting no later than 90 days before an election. This bill would require the association to deliver individual notice to each member that includes certain information about voting by an electronic secret ballot. And under the law, the electronic secret ballot is effected when transmitted and it is irrevocable. So please note that while this provides options for members, this also has the potential for complicating elections. For example, members are able to opt in or opt out of electronic voting. So moving forward, associations will likely have elections where there's a mix of electronic and paper balloting. Next is AB 2460. If you attended my case law update earlier this year, you may recall that there was a new law that went into effect at the beginning of this year, January 1st, 2024. This new law cleaned up and addressed the ambiguities in the earlier law. Clarifies the process through which an association may adjourn a meeting to a preceding date at least 20 days after, at which time a quorum requirement would be 20%. Please note that this only applies if the association's governing documents require a quorum and only for director elections. Obviously, this means that the process would not apply for other member voting. It would apply if a quorum is not required for director elections, and it would not apply if a quorum is required by the governing documents, but the quorum states that that threshold is less than 20%. Next is SB 900. This bill provides that unless otherwise provided in the declaration of the CID, the HOA is responsible for the repairs and replacements for matters relating to the interruption of utility services, think gas, water, heat, or electrical, that begin in the common area, even if the matter extends into a separate interest. This bill states that it does not apply if there's a state of emergency. The new law would require the HOA to commence repairs or replacements to interrupted utility services within 14 days. And it allows that if a vote does not take place within the 14-day period and there are insufficient reserve funds available, an HOA may obtain financing to pay for repair costs without a vote of the membership. Again, this vote may take place by electronic means, such as email. And if substantial repairs are needed to a utility service of common interest development, a representative of the utility shall address the HOA in person to present the description of the problem, suggested solutions, and expected timelines. So when preparing this presentation, I was initially unsure of how this might actually play out. So I thought I'd provide a case study. In 2023, a gas leak in a 200+ unit condominium building in Orange County was discovered, and citing safety reason, the local gas company shut off service. So residents had no access to hot water or cooking or laundry facilities for months. The gas company claimed the gas lines were owned by the condo. Therefore, the HOA and management company were responsible for fixing the problem. There were concerns that the building would be red tagged by the local building officials because of health and safety code violations, and that hundreds of residents would be displaced. So after weeks of disputes on who was responsible and where the leak originated, the HOA took out a loan to address the costly emergency assessment, splitting the costs among all of the building's HOA members. Now, this law attempts to prevent a situation like the one in Orange County from happening again. Now, if the bill had already been in effect, clearly stating that HOAs are responsible for commencing the utility service repairs and replacements in the common area within 14 days, then the HOA in Orange County would have had to address the problems much sooner. Next, again, I just want to cover the Corporate Transparency Act, just given the upcoming obligation to comply. It applies to two types of reporting companies that will be required to submit BOI reports. To be domestic reporting companies, including LLCs, corporations, and other entities formed through filing with the Secretary of State. And it also applies to foreign reporting companies that are registered to conduct business in the United States through filing with the Secretary of State. So as you'll see on this next slide, most CIDs would qualify as domestic reporting company because they're either nonprofit mutual benefit corporations, they're stock co-ops, or they're entities formed through filing with the Secretary of State. So this would appear to be inapplicable for unincorporated associations that did not or do not file with the Secretary of State at formation. Next, yes, there are 23 exemptions. 23 types of entities that are exempt from the beneficial ownership information reporting requirements. But these entities include publicly traded companies meeting specified requirements, many nonprofits, and large operating companies. But this would only apply for CIDs that have tax exempt status with the IRS as a 501c entity, not merely being a nonprofit mutual benefit corporation. Next, let's see what the report requires. A beneficial owner is an individual who may either directly or indirectly exercise substantial control over the reporting company or owns or controls at least 25% of the reporting company's ownership interest. So what is substantial control? An individual can exercise substantial control over a reporting company in 4 different ways. If the individual falls into any of the categories below, that individual is exercising substantial control. So 1, if the individual is a senior officer, think president, CFO, general counsel, chief executive office, or chief CEO, COO, or anyone who performs that similar function. Second, if the individual has authority to appoint or remove certain officers or a majority of the directors of the reporting company. Third, if the individual is an important decision maker for the reporting company. Again, kind of ambiguous. And fourth, the individual has any other form of substantial control over the reporting company. Again, not entirely clear. So where does one report? If you're required to report your company's financial or beneficial ownership information to FinCEN, you will do so electronically through a secure filing system available on FinCEN's BOI filing website. That's there on your screen at the moment. I'll leave that up for a little bit just in case anyone needs to write that down. Okay, moving on. So when is one required to report? A reporting company created or registered to do business before January 1st, 2024 would have until January 1st, 2025 to file its initial BOI report. A reporting company created or registered in 2024 will have 90 calendar days to file after receiving actual or public notice that its creation or registration is effective. A reporting company that was created or registered on or after January 1st, 2025 would have 30 calendar days to file after receiving that notice that the creation or registration is effective. Now, if there's any change to the required information about your company or its beneficial owners in the report that was filed, a company must also file an updated report no later than 30 days after the date of change. So keep in mind that the individuals that would need to report, this would mean that if there is a change in any of the officers or anyone who has substantial control, anytime there's an election, if there are new presidents or other officers, and that report should be updated within 30 days of the date of the change. So, and the need to file updated reports beyond that are going to vary company by company, so I won't get into the details beyond that. So next, the Corporate Transparency Act was enacted to combat money laundering, tax fraud, and other illicit activities by requiring certain business to disclose information about their beneficial owners, but the reason to comply is that there are fines. So please, do reach out. I do think that Echo has some information about some potential options to go for if you do need a BOI to report. So I'll turn it over to you, Dave.
Okay, thank you. Appreciate that, Louis. Yeah, to enable and to help our membership out, we have done an outreach to a third-party provider of reporting services, CTA Review. And of course, you have to file by the end of the year for and have it filed for the first of the year. So if you're interested in this particular relationship, they can help you with your questions, with your setup, everything, and then they'll notify you each year, several times during the year, to remind you that you have to change things if you do have things to change. So we work with Natalie over at CTA Review, and if you use the promo code ECHO when signing up, we'd appreciate that, so they know where the lead is coming from. We actually don't get a beneficial, we don't get any benefit out of this. It's just a service to you folks, and wanted to make it easier for you to comply because we had a lot of folks that were a little behind on this one. But you can also check with your management company. They may be able to help you as well. The management companies will charge a little bit for the service. The CTA Review is $295. Again, use the ECHO code when you're reaching out to them. Telephone numbers on the screen as well as the contact information. We'll be sending that out to you if you haven't already received it in your slide deck. So thank you for that, and we look forward to having that. Right now, we're going to go to our Q&A session, and we have a few folks to remember and thank, and of course, Louis Sarmiento from Shearer Smith and Kinney for his presentation, and thank him for supporting our Q&A session. What I'd like you to do in the Q&A is to go to the Q&A feature and upvote on the few questions that we do have. We don't have a lot of questions today, so if you could upvote on your favorite question, that would be very helpful, and we'll go ahead and call on the first one. Make sure you keep your questions relatively short. There's a couple that are fairly long, so just if you could do that, it would be appreciated. And then we'll go ahead and let Louis start making some calls here in just a second. So again, thank you for the presentation, and we'll do the Q&A now. Use the thumbs up.
So I'll address the first question with the highest upvotes. Question is from Natalie. How do we collect from homeowners with extensive unpaid balances? Please work with your manager, but my practice as HOA counsel had always been to work with a company that does provide assessment collection as their service. Now, obviously, as we saw with ALS, that there are some issues with how some assessment collection companies might have operated in the past. So, but anyway, because of the highly technical nature of the lien recording foreclosure process, it would be best to work with a company that does this on a day-to-day basis.
Okay, so let's go ahead and question the next question. Anonymous attendee, what was the end result of the Morris v. West Hayden Estate case?
Yes. So in that case, I guess the question is probably more situated to what the underlying case was. They found that on one of the three claims, there was adequate evidence to show that there was, and this specifically was 3617, so which says that it's unlawful to coerce, intimidate, threaten, or interfere with any person in the exercise or enjoyment of, or on the account of having those rights exercised or enjoyed. So the court found that there was enough evidence to proceed with that claim. So yes, they as to that one, they found for Morris and against the association.
Okay. And Alpha asked a question, just a definitional one, I believe. It says, what does facially neutral mean?
Yes. So in that piece, if there is something that on its face doesn't prefer or hinder any particular religion or protected class, I mean, much has been made with the national election lately about voter IDs. So, I mean, I guess it could be argued, and it has been argued by some that that has a disparate impact. So the difference between what the appearance of what the law does or how it affects others, and what it actually says on its face might not appear to be either benefiting one group or explicitly harming another group. Implicitly, or a less obvious result of that is that it might have a disparate impact. So I hope that answers your question. It's more about what the impact ends up being as opposed to what it states its purpose to be.
Okay. So anonymous attendee requests clarification on the 20% quorum. Does the 20% reduction apply to governing documents? Apply if the governing documents have a reduced quorum, but it's more than 20%?
Yes, that would apply.
Okay, and it says here from Lisa, if it applies, how does it apply? Well, so it does apply, right? So
It does apply, and remember, this deals with director elections.
Right.
So because it deals with director elections, one problem, especially in many associations, is voter apathy. So if you have a number of seats available, but you can't get 50% plus one, then you might be in a situation where the board can elect new directors. So with this reduced quorum requirement, 20% would satisfy as quorum, and the highest vote getters would get the seats that are open.
Okay, well, if their reduced quorum is above 20%, can you just slip directly into ignore that reduced quorum requirement and the governing documents and go to 20%?
I guess the question from Lisa is there, if the reduced quorum in general, or the second step, the reduced quorum for the subsequent meetings. So if there is a quorum requirement that in general is greater than 20%, then you'd have to go through this two-step process, try to have that first meeting and adjourn. And then at that second meeting, it would be 20%. So I guess as an alternative, if in Lisa's question, if it has a higher threshold for 50% plus one, and that in the subsequent meeting, it would be 25% or 33%, for example, then you can ignore that higher threshold in the second meeting, in which case you'd use the 20% instead.
Yeah, so that's a matter of law. So that's why. Okay.
Correct. Yes.
Okay. So Alpa has lots of questions all the time. So in Dubach v. Itkoff, was there a defamation or not?
So this case did not get into it, again, because it deals with anti-SLAPP. The litigation starts off on one track with the defamation case, and then by filing an anti-SLAPP motion, you basically take the litigation on a second track, in which case you're not quite a parallel track, but it keeps that initial cause of action on hold while the court considers whether or not the freedom of speech was infringed upon, and whether or not there actually is an issue of an anti-SLAPP. If there is, and if this violates the anti-SLAPP law, then the underlying litigation would go from being on hold to being thrown out. But here, since the court found that it was not triggered, then the case that was on hold, gets taken off ice, and then the trial court goes back and considers the claims.
Okay, sounds good. We have CTA. This is again from the anonymous attendee out there. CTA, will separate directors receive their own FinCEN ID number after filing? I think it's actually Connor knows the answer to that one too.
So each director would have their own FinCEN ID, and then your organization would have one FinCEN ID with all the directors under it, is how it works. So you would file as a board member to get a FinCEN ID, and then you would provide that to the person who's filing for your corporation. And then your corporation would then have its own FinCEN ID with all the directors underneath it.
Do you have any comments, Louis, on that? Nope. Okay, I have a comment. Yeah, so any of our members that have questions about CTA, they can always call Connor. He's been trained by our CTA reviews. So Natalie. So if you have a question, just go ahead and give him a quick call, and he'll be able to help you out a little bit. Again, he's not an attorney. This isn't his primary role, but he has a little training in this, so he can help you and guide you in your process. And even before you go to CTA review. So if you have any problems, give him a call. All right, next. We don't have any specific ruling regarding the decimal noise, regarding garage door. So homeowners complaining to bring a lawsuit. So I guess they have a garage door noise, and the owners are complaining and threatening to bring a lawsuit because 3 neighbors' garage door noise. How would you deal with that? We are in San Jose, California. I call the city of San Jose. They do not have specific rules regarding garage door noise either. So it's a nuisance question, I guess. And
It is a nuisance question. Since it deals with potential litigation, I prefer we not get into it, but ultimately it's going to come down to experts. What experts.
Yeah, and you may check your governing documents. It's a clue, because we get a lot of noise complaints, requests, or requests for help. And your CC&Rs, maybe even some rules, have nuisance requirements, and so check those first and see what those are. If you don't have anything there, then it's going to get a little messy. But this is going to deal specifically with your HOA, the way it's going to be handled. So get your own counsel lined up there. Louis he doesn't know enough about your specific situation, so he can't really answer that. Okay. And it says here, Jay says, are internets considered utility services that HOAs would have to address problems due to maintenance of wiring?
So I guess it's a threshold issue, is the consideration is whether or not that wiring is considered common area. And if we're talking about internet, many times, I mean, I guess if we're talking about fiber, many times that cabling is going to be, it depends if this is a fiber, I represent a high rise in the city that has fiber that is common area, or rather it affects multiple units, but for that situation it's owned by the fiber provider, and then if anything goes wrong, the fiber provider would come out and repair it. So it depends on who's responsible for the maintenance of the underlying wiring, as opposed to just the whether or not this is a utility service.
Okay, so that sounds good. Let's see here. We have and if after all assessments are caught up and current, could there be interest on unpaid late fees or other uncollected debt on the account? So this is the one regarding the lien.
Yeah.
Case regarding lien. Yeah.
So generally interest is it accrues on unpaid assessments. And that's also why this law went into place, to try to prevent the situation where, like we saw in the ALS case, where they paid over $5,000 on a $1,000 debt, and that during that time period, interest continued to accrue. So in that situation, after that homeowner paid the $1,000 I was owed, they still may have collection fees and costs. I'm sorry, the cost of fees and collections, because under the Davis Sterling Act, an association can pass that on to the homeowner, but that interest should not accrue on that, and also the association should not be attempting to foreclose upon a homeowner for unpaid collection fees as opposed to assessments themselves.
So that's good. Next one. So Alpha asks, and DOS cuts. Do interest and fees come out first? It will be helpful to summarize the results in lay terms. So,
Yeah, so on that one, again, it's assessment comes first.
okay.
So Doscox, they owed $1,000, 12, a little more than 12. That first $1,200 should have went straight to paying that off. And then fees and interest comes after, but fees should not continue to accrue once that initial assessment has been paid off.
Okay, sounds good. So Daniela asks, do HOA directors need to simultaneously file with FinCEN?
As long as they're part of that, they have substantial control, then yes. Well, simultaneously, I guess if the question is whether or not they should be filing separate from their organization.
Which is no.
Right.
Yeah, so for you, Daniela, each director can make their own FinCEN ID number whenever they want. It doesn't have to be done simultaneously because that is an individual profile for the individual director. However, when filing for the corporation, you would need all of the FinCEN numbers from your other directors first. So there's kind of a two-step process here. All your directors would need to get their own FinCEN number. Then whoever's filing for the corporation would enter those all in at the point of filing for the corporation. So there's two separate lines there.
Yeah, sounds good. Thank you for the clarification, Connor. Let's go to the next one. We actually are starting to get quite a few questions here. So make sure you use your upvote so that we can prioritize here, please. Can directors perform a CTA filing individually, not together with the board?
That's a no.
Okay.
You don't want to do that because then say you live in 123 HOA and you all file individually for 123 HOA, there's now going to be 9 123 HOAs. And you don't want to do that because that's going to get the authorities that be to come and inspect your association and figure out why there's 9 of you instead of 1 with 9 directors.
So Bob asks, one claim by homeowner was upheld by the appeals court. Remind me what the claim was, not just code number, and please tell resulting impact on HOAs. You know what he's talking about here, Louis?
I'm thinking that I don't know. It would depend on which one, because there's again, some of these were kind of secondary or like the anti-SLAPP. It's separate from the underlying claim.
Okay, so we'll take a couple more here. If you want to clarify that one, Bob, then that's great. Go ahead and clarify, put it in. Lori Campbell, my understanding is that on January 1st, 2025, has been extended for a year. Have you heard anything about it being extended for and you're talking about the CTA, we're going to assume that, Lori, so.
I don't know. I mean, that also might be reference to.
That's SB 326. It's down below.
SB, well.
For balcony inspections.
Lower, I guess it'd be 2144.
Yeah.
Oh, I see, for balcony inspections. Okay, so that, yeah. Lori, I think there's some confusion about that, just generally. For HOAs, it hasn't been extended, but for 721, which is the rental apartments, it was extended a year. At least that's what I'm told.
Right, and in AB 2114, that has the language dealing with the balcony inspections, section 5551. it still reads as being the first inspection to be completed by January 1, 2025.
Yeah, we received that question before, and there's a little confusion in the marketplace. Okay, so let's go to the next one. Alpa again has got lots of people interested in their questions. SB 900, our HOA is not responsible for utility lines. The local water company, sewage company, and PG&E are responsible. Is the HOA still responsible for fixing I assume any disruptions or lack of service going into the community?
Right. Again, it still depends on the obligation. So if it is something that the association's responsible for repairing, it ultimately comes down to who's responsible for the repairs and replacements. And if it's explicit in the governing documents that this is something that the association's not responsible for, then it wouldn't apply, but it depends on, each particular element, and it depends on each particular association and how common areas are defined.
Okay, well, I think I'm going to go ahead and call it today for the Q&A part of this, and we'll go move into our closure, and we'll also hang around for a little while afterwards. But Louis, thank you so much for participating today. Very much appreciated. And we look forward to seeing you every 6 months or so to give us the updates on the case law. It's always fun to go through that. And thank you to all the attorneys that came on the call today as well, that are in the audience listening. We appreciate that you come to this too, and all, of course, our board members. Importantly, I want to thank all the ECHO members for coming today and participating in our ECHO webinar. It's been great having you here. Thank you for using one of the benefits of your association membership. For those of you who are not ECHO members, please consider becoming a member and supporting the HOA boards throughout the country. To join, simply go to www.echo-ca.org and click on to the membership tab and join. I think we have someone from Canada today, so we do have them, a smattering of participants across the country. So there you go. For ECHO members, thank you for supporting us, and please invite your friends, boards, and especially management firms and vendors to join ECHO. A simple invitation is often all it takes to motivate them to sign up and join. If you would like to become more involved with ECHO, we have a few opportunities for you. Please refer to the slide. If you see anything that looks particularly interesting to you, please let me know at dzapponi@echo-ca.org. I saw Glenda is on this webinar today. Thank you so much, Glenda. She's volunteered to help us out as well. So we have a whole slew of folks. Kay Dyack's on there, and I saw Peter Shapiro. So we have folks that you'll be able to see in person at the Walnut Creek event. Now, for our other announcements, this year launched a new educational program focused on HOA board preparedness. The core curriculum of 10 courses is designed for high quality training and is available for HOA board members, interested homeowners, and professionals. Your participation in this program will earn you the certificate of HOA board member preparedness. We appreciate you coming and participating. I think we had 32 or so folks signed up this year. The courses will initially be offered live via webinar, with 8 of the 10 courses recorded. And if you missed the live program, the courses will be offered on demand as a recording. So if you or someone you know wants to enroll in the certification program, please send an email to Connor. He'll be able to help you. His email address is currently on the screen, so you can write that down, but it's connor@echo-ca.org. We are now heading into the final stretch of the resource panels for 2024. Our last set of resource panels will begin on November 12th with the Wine Country panel. That's next week, where they will discuss holiday infractions. And we head over to the North Bay and San Francisco on the 13th. And they're going to be going over tree maintenance during the holidays and assessing and preparing the association for the new year. Then we will move over to the East Bay on November 14th, where we will talk about electronic voting. And so we have an attorney that's going to speak there. And we look forward, if you're interested in electronic voting and the new law, there will be a presentation there. We also have one larger in-person meeting that's coming up this year. Our final one is on November 16th, and we will be having our annual legislative update and educational seminar. You can learn all about the new laws that were just passed this year in the legislature, and it will be held at the Rossmore Event Center in Walnut Creek. If you can't make it to Walnut Creek, we will also be simulcasting the entire program via Zoom. And so we have a number of folks that are signing up, especially in Southern California and outside of the Bay Area. So if you would like to attend, please sign up and join us via Zoom. Once again, I want to say thanks to Louis for his important case law update. And of course, thanks to all of you for attending today and making this a successful event. ECHO appreciates your investment in education to foster a better quality of life in HOA communities.